Hey everybody, welcome back to the Consumer Warrior YouTube channel. My name is John Skiba and I am a consumer defense attorney and bankruptcy attorney in the state of Arizona, and I'm founder of the Consumer Warrior YouTube channel. Today what we're going to talk about is really helping to put your mind at ease. I know that you get sued by a junk debt buyer or an original creditor, you get that process server coming about with the complaint and the summons and you just freak out because you don't know what's going to happen. Well, today I'm going to give you really your legal roadmap as far as what to expect in a debt collection lawsuit, why you shouldn't be as worried as you probably are at this point, and give you some tips and strategies as far as defenses you can assert to be able to get this thing dealt with once and for all. But if this is your first time here to my YouTube channel, please go ahead and click subscribe. Just do it. Everybody's doing it. Click subscribe. Check on that little bell. That way you'll be notified each and every day when we put out new videos that'll help you deal with serious debt problems like junk debt buyer lawsuits. Let's talk about debt collection lawsuits. And specifically, we're going to talk about both junk debt buyer lawsuits like Unifund, Midland Funding, LBNV, Resurgent, all those kind of companies, as well as original creditor lawsuits. Like American Express, they usually file their own lawsuits. We see this with Capital One. Sometimes we see this with JP Morgan Chase, where the original creditor who you had the credit card with, they actually bring the lawsuit. Some creditors, Synchrony Bank, Web Bank, Citibank, they often sell their debt to junk debt buyers. These other companies who buy debts for pennies on the dollar and then file the lawsuits. So I know that when you get the lawsuit, it's hard not to just freak out and to go to the worst place in your mind, as far as what's going to happen. And what I have found, I've been doing this for over 20 years, I've done over 400 trials against debt collectors, is having some sort of peace of mind about what's going to happen. And if you've never been in the legal system before, you don't know what to expect. You just go to, something you've seen on TV and think that this is going to turn out really horrible. So what I want to do today is walk you through what the general process and flow of a debt collection lawsuit is and what you can expect from it as far as maybe some defenses, and give you a few options. So the first thing to understand is when a lawsuit is initiated by the creditor, they will go to the court and they will file the complaint. In some jurisdictions it's called the petition. They'll file that with the court and then the court will issue them a summons. The summons is the document that tells you how much time you have to respond, what the court is, that you're being sued, and then they typically have to hire either a private process serving company. Some jurisdictions use the sheriff's department. Arizona actually has constables. I don't know why I always think that's kind of funny. It sounds like something from England, the constables out there, but it's nothing like England. It's like a cop with a gun and they show up to your house with the summons and complaint. But they have some company. Somebody brings this by, somebody who's authorized to bring that by your house. Typically, in-person service is required. So they have to bring it by your house, knock on your door, and hand it to you. In Arizona, they can hand it to you or someone who lives with you as long as they are of suitable age and discretion. And you may be asking, what does that mean? Nobody knows. It usually means like your 5-year-old's not going to be able to accept service, but your 12-year-old might be, or your 13-year-old. I have 6 kids and I wouldn't trust all of them to accept service for me. But the law says, hey, if they look like they're reasonably responsible, they're at the doorstep, they can leave the summons and complaint with them, and that counts. You've been served at that point. Once you've been served, and let me back up just really quick, because it is possible in some jurisdictions they allow you to be served through the mail. So if you get a complaint and a summons and you receive it in the mail, don't ignore it. I don't think that, okay, nobody came by my house, so this must not be legitimate. You should contact the court, contact the opposing attorney, see if this is legitimate before you fail to take any action. Not only that, if they haven't been able to catch you home, which is rare, I can say these process servers, they always tend to come by at the most awkward time, Sunday mornings, Saturday evenings, things when they expect people to be home. But if they can't catch you home, or if you're dodging service, you're trying to avoid the process server, in some jurisdictions like Arizona where I practice law, they can actually go get what's called an alternative service order where the judge will allow them to serve you through the mail, allow service through email. In the old days, 10 years ago, they would even allow them to post it in the classified ads of a newspaper. And for the younger viewers, the newspaper is this large piece of paper that the news used to be printed on. The whole point here is if they serve you, or if you get a complaint and summons and you see it, you need to do something with it, take action with it. My general recommendation, don't avoid service, just get it, receive it, and then let's put a plan together on how to deal with it. So once you've been served though, that starts the clock ticking for you to respond. So look in the summons and look and see how many days it says you have to file your written answer. Most jurisdictions just require you to file a written answer. There are some jurisdictions that will actually set a hearing date where you need to show up. Either way, put it in your phone, put it on your calendar, circle it, whatever you're going to do. Make sure you don't miss that date. Statistically, over 95% of debt collection lawsuits end in a default because people do not respond, either because they don't know what to do, they were served improperly, or they just freeze up and just say, I owe it, so I'm not going to do anything. Even if you're like, hey, I owe this 100%, it's a good idea to file an answer. If you're not sure what goes in an answer, if you're in Arizona, we can help you. If you look below, there's also some templates, tutorials through my Consumer Warrior University that can help you. We also partner with SoloSuit, which is a great company, and they can help you. They have this online platform that'll help you to draft the answer. The answer, as far as debt collection lawsuits go, the answer is the simplest step that you can take to avoid a lot of big problems down the road. So once you get served, you put that in your calendar, in your phone, put a reminder as far as when that answer is due. Once you file your written answer, and the answer is really just you stating whether you admit or deny what it is that they're alleging in their complaint. Basically, the court wants to know, do we have a dispute here, or does everybody just agree on everything? Once you file an answer, then the case will typically go into a disclosure/discovery period. In most jurisdictions, within 30 to 40 days after the answer is filed, the parties will exchange disclosure statements. Now, the disclosure statement is really where both sides have to show their cards. The days of Perry Mason, trial by ambush, those don't exist. If you're going to use something to your defense, and if the creditor is going to use something to support their claims, they've got to provide it to you in advance. So they've got to disclose witnesses, their claims, list of their documents. Most places they have to actually provide you a copy of their documents. And the vice versa is also true. You've got to provide any documents you have, any witnesses you tend to use. It's not uncommon. I know I defend a lot of people who are being sued that they don't have documents. That this is being sued on a credit card from 5 years ago. One, a lot of people don't even get written statements anymore, and two, they don't keep them. So it's not unusual that my clients don't have a lot of documents, but if you do, or if you've raised a dispute, if you filed something with the credit reporting agencies, if you disputed it directly with the original creditor, those are the types of things you need to look at. Now, it's important to know I divide debt collection lawsuits really into two categories. There are original creditor lawsuits, like I was talking about, where the actual credit card company you had, they're the ones suing you. The American Expresses, Capital One, JP Morgan Chase, people of the world, and then the junk debt buyer. They're in a separate category: LVMB funding, Resurgent, Portfolio Recovery, Unifund, and a billion others. Those are companies that they went out and for pennies on the dollar, they buy huge portfolios of debt, they sue people, and then they garnish wages and bank accounts, and that's how they've chosen to make a living in this world. So I take different strategies for both. I should tell you this, that if it's an original creditor lawsuit, American Express, unless you have a specific defense as to identity theft, someone stole the card, unauthorized charges, those types of things, then I usually recommend you really focus on settlement, because they're going to have the documents, they're going to have the witnesses to be able to establish their case. So unless you have one of those defenses, I usually recommend, even before I file an answer, we focus heavily on what can we do to try to settle this case. If it's a junk debt buyer suit, though, they have a much bigger burden of proof. And it's important to remember, the plaintiff, who's the creditor who's suing you, they bear the burden of proof on your case. They have to prove this. You don't have to disprove it. And so the junk debt buyer has to prove not only that you had the original account with the original creditor, they've got to show what the terms of that were, they've got to show that you didn't make payments, they've got to show how they're calculating the amounts owed, and then they have that big hurdle of showing that they own your account. Not that they own a big pool or a portfolio of accounts, but they own your account specifically. That's often where they struggle because they don't have the witnesses from the original creditor. They only have their own employees. They struggle to get documents admitted into court, those types of things. So there are other stronger defenses you can use there. So once you get through the disclosure period, then they can do discovery. The parties can take depositions, which is like oral testimony where you actually do like an interview. You can do their people. They can actually come in and do a recorded one, with a court reporter view. More common is things like requests for admissions, requests for production of documents, and interrogatories. This is written discovery. They send you questions, you send them questions, and then the parties have usually 30 days to respond to it. Once that stage is over, typically that's when the courts will either set a pretrial conference to give you a trial date, or they may require the parties to participate in what's called mediation. Some courts call it a settlement conference. This is where they appoint an independent third party to come in and meet with the parties and see if there's some type of middle ground that can be reached. If you're trying to get a settlement and they're not being reasonable, this can be a good opportunity to get the case settled, because you'll have somebody there kind of putting the screws to them and to you to get some kind of deal done. A settlement is never mandatory, but it's a good opportunity to try to resolve it. Then the case will typically proceed to trial. However, it's important to know in almost every single debt collection case, if the case doesn't settle, if it goes through mediation and doesn't that, you will get what's called a motion for summary judgment. The motion for summary judgment is the creditor's way of saying, hey judge, we don't need a trial. Just look at all of our evidence and tell us if we win. You are required to respond to that, and it's different than responding just to the complaint. The complaint, you can basically admit or deny what it is they're alleging. The summary judgment motion, they still bear the burden of proof, but now you have to come in and kind of pick it apart and say why judgment should not be entered. Now, the junk debt buyers, their attorneys, the original creditors, their attorneys, they know that self-represented people struggle with the motion for summary judgment. They know that it's more complex, it's more difficult. You usually have to do legal analysis, cite the case law, cite the rules, and so they know that this is for a lot of people where they're going to get them. I do have a tutorial in the notes below on how to respond to a motion for summary judgment. I have a template in there that can help you and give you some ideas if you're working on that. But it's important you respond to it, and if you're not sure how to do it, this is where it's important to get an attorney. If you're in Arizona, reach out to me. My contact information is below. If you're not in Arizona, you can still, there's a link below you can click on and we can get you connected with an attorney that does what I do and can help you with the case. And then if you defeat the motion for summary judgment, then it will often proceed to a trial. Most debt collection cases are dealt with in a bench trial, meaning the judge is the one who decides it. However, you can request a jury trial. So that's a possibility as well, to have a jury hear your case. So that's kind of a big overview, and I can warn you ahead of time, typically the wheels of justice move super slowly in debt collection cases. It can take anywhere from in some jurisdictions, 6 months, up to, if you're in Arizona and being sued for more than $10,000, it could be up to 2 years before you get an actual trial date. So it takes a long time, and in the meantime, you can still try to work things out. The 3 basic approaches to any debt collection lawsuit: you can fight it and litigate it, you can settle it for less than the amount owed, or you always in your back pocket have bankruptcy. A bankruptcy will stop the lawsuit and eliminate the debt. So if I can be of help with any of those things, check out below. Again, even if you're not in Arizona, check out my information below, fill out our little form, and we can connect you with an attorney who does what I do and can help you deal with this thing once and for all. Thanks for watching today.